at all, or what I believe was going on. It may be that there's one thing I can say. Ashley did show, from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever, I don't know. But she could put up a good front, and this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. You know, her getting in that. I guess you referred to the first visitation.
Yes, at the sheriff's office.
Her going along, that's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson, and so yeah, that was definitely the mother, the maternal instinct, wanting to protect her daughter. And at her own expense, but that's nothing. I'm a parent. I take a bullet for my kid. You know, it's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm the neutral party here. But in this kind of situation, in a Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I have said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, object. Please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that, Judge.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? In my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy to verify that that's the complete version.
Sure, we'll see.
Yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
Get it back? Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pen markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
Judge, if I may, it's a defense's burden. My only concern about your asking questions is that they have arrested their witness, and I understand what Your Honor, I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but.
I mean, don't forget there's also the general and proper. So, you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing them down as we went, and I'm taking notes. I only got 12.
Okay. So do you want me to briefly?
I don't want the narrative portion.
No,
I just want you to tell me.
Or you tell me. Okay, I'll tell
No,
you.
it's got to be the other one. You have to say
Okay,
to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number
A
3,
little slower.
okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony. And number 13 was the text kick dog through cat and between Ashley and Doug.
Can I just ask to verify, you said phone calls between Ashley and Doug? Is that what you said?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
You have transcript of phone calls?
I believe so.
No.
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir, thank you.
Mr. Taylor, do you have any questions based on my questions?
No, Your Honor.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
Okay.
So stay in touch.
Okay, and so I'm still under my subpoena?
Yes, sir.
Thank you, I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or was that yours?
That's theirs.
Okay.
I got mine. Thank you, sir.
Safe travels back home.
Yes, appreciate it.
Wait, we're looking you go right at the perfect time, aren't we?
Yeah.
Might want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State? Did you have any evidence testimony you want to put on?
No, sir, thank you.
All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the three requirements, sufficient, if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and three, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to, and included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know, and what the record reflects, based upon Mr. Ferris's testimony and the Duluth Power Wheel, and its model for the evaluation of domestic abuse, is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So, here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But, as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. it carries over and it explains under Duluth Power and Control Wheel why Miss Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try.
Please don't get mine. I'm sorry.
Why she would try to get along, go along. So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the 2nd DCA.
Oquendo,
Yes. No, this is Wyand.
Wyand.
Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999. The Supreme Court rejected the 2nd DCA's position in the Wyand case and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, Implications for Victims of Domestic Violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyand help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyand goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind in the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions. Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Ms. Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Ms. Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Thank you, Your Honor. Judge, I'm going to try to bring it back to Daubert, but I do want to address Akendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome, and part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Wheeling case also defines battered spouse syndrome. It says,
You want to spell it?
sorry, it's a case Mr.
Wyand?
Oh, I'm sorry, Wyand.
Whatever, however you want to say it. I see another one.
W-E-I-A-N-D, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important in the state asset is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits that's not what he was doing, there's only two options for that, and Your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we are allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased, because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says, if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder, and it certainly goes to her depraved mind, but the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert, scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but ultimately I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Or y'all can have a seat. Welcome back, everybody. Over the lunch break, did anybody talk amongst yourselves or discuss the case in any way? Did anybody talk with anybody outside of the jury about the case? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about? No, sir. Everybody says no. So, State, you may begin your cross-examination.
I would like to just start with a couple of issues. So first, Benefield never punched you, ever, correct?
Yeah, I think that's correct.
Doug Benefield never choked you, ever.
No,
He never kicked you.
no.
He never pointed a gun at you,
He waved a gun in my direction.
but it was not pointed at you, correct?
It was pointed at me while he was waving it at me.
He never came at you with a knife,
No,
or a club,
no,
or a baseball bat.
no.
So there are 30 years difference between you and Doug, correct?
Yes,
And you got married after 13 days.
yes,
And you spoke with him about, or organized with him about starting this ballet.
yes.
Okay. And all of the money for the ballet came from him or investors, right?
My mom also funded part of the ballet.
You didn't put anything into it. Money.
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No,
He didn't.
he did not pay for the cruise, no.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go, so.
Okay. So he paid for your friend to go?
Yes.
And he did not go with you?
Oh, no. Mm-mm.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. And I have the entirety of it on a spreadsheet that I'm going to put up, which is State's Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, State would enter into evidence State's 99.
Did you want to be heard in addition to what we said earlier?
I haven't actually seen the specific message.
Any objection to State's 99? Received.
So I'm going to put this up on the board behind you, screen. trying to get it to come up on the screen. Okay. So I would like to orient you to what we're looking at. So on the top line, it gives whether the messages are outgoing or incoming. That would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. Oh. My ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. Like, always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug? Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen. So yes, my love, I think was the last thing you said. And then what's the next thing?
Are you doing things that are dangerous?
And you're going to have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me, and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip?
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. And then a rectangle. It makes me so sad. And then another rectangle. If I dwelt on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself, and you were easy prey for predators. You're sweet and want to please people, and they used that.
And you said? I'm sorry, and then he said?
I desire to exterminate them and hold a challenge. They are rats that should be removed.
And you said?
Oh, baby, my love. Yes. Like that night, like last night. Just the jerks arguing near you about put me in a sheer murderous mood, but I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, what could have been a fight, etc. Only you being with me will over time remove images in my head. It is same, and knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but...
Can you pull that back up?
He said it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad, I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
I guess you could put it that way.
Okay. You can continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person, with your legs spread, and a shitty person choking you out. That haunts me. I love you, and I never want you. I'm sorry, rectangle. Now all I see is some douchebag on top of you, fucking you with your legs, choking you out and fucking you more. Right now, I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband, who is gentle to me and kind. He said, we went from joy and passion to now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
So this conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had had with him explaining that this had happened.
I think he was referring to, on the cruise, one night I was talking to him on the phone, and I was sitting out in the hallway up at the top deck, and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some, like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were
Okay, I'm
talking,
gonna stop you
he
there.
heard,
Is the answer yes or no? Did,
You need to allow her to finish her answer, Your Honor.
Let me finish your answer.
he had heard a couple of guys that were talking loudly, and he got upset because he thought these guys were going to hurt me. And so he had talked about then that he imagined that, you know, I was out in the world without him and that people were going to take advantage of me and that it was going to happen to me.
and he was afraid for your safety.
Yeah.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him into a rage.
Yes.
And that scared you.
I'm sorry.
And that scared you.
Well, as I said earlier, at the time, I kind of, you know, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, you know, manly.
Okay. So I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that.
Part of it went on my debit card or my credit card.
And your intention was to get pregnant.
Yes, we had talked about that, yeah.
And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April. 7.
And was this, during this time, you said he had started criticizing you, right? About the way you looked, your clothes, the way you acted. He was, according to you, he flipped a table, tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore,
Yes.
and you want a baby.
I mean, yeah, we were married. We wanted a family.
Okay. So the vasectomy reversal happens, and I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then. You know,
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy.
The doctor had told us that it probably wouldn't work for a while, so it wasn't something that we thought would happen that fast.
Okay. But it did.
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a wall.
He threw it at me.
Shot a gun at the ceiling. I think you made several allegations, correct?
He admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that
Okay.
were not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
10 years, 9 years, 10 years.
And this tension surprised you.
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own.
Oh, I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture. It had like deep sides and like the glasses at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote a saying on it that said something about how like you can be strong through the storms and that, you know, seashells are beautiful things that come out of storms.
And that shadow box is the reason you were arguing that day with Doug, correct?
I know it came up at one point. I don't know that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad. I'd taken a lot of time to make it for her, and I thought it was special. And
And you began crying,
yes,
and you dropped to the floor and sobbed hysterically.
probably.
You were so upset that she put her dead mother's rose in the shadow box.
It wasn't that. It was that she took it apart. I mean, I would have bought her another shadow box,
You went to Doug and said it was disrespectful that she took this apart.
according to Doug.
No, according to you. You went to Doug and said, she's acting disrespectfully. You need to handle her. She upset me. I'm crying.
I don't remember saying that about that.
Isn't it in fact what you were arguing about before this whole incident with the gun and the ceiling?
Is this relevant as it relates to the daughter?
Can you approach, please?
So the day that this argument happened, you actually at one point were in the car with Doug, right?
Yes,
Okay, you were going to the bank and going to do some other errands.
I believe so.
And the entire time you're upset about this shadow box.
I don't distinctly remember. The argument kind of came from there, I guess.
And in fact, it wasn't an argument, right? It was you being upset.
He said that like life was out of control and he couldn't deal with the people at home and he couldn't deal with the people at the ballet. And he
Did
felt
he-
like everything was just too stressful and he was upset with everybody.
And didn't he ask you to stop?
Sure, at some point.
And you didn't stop
I guess not.
for the car ride? No? Yes or no?
I don't remember.
And you kept telling him you need to discipline Eva.
I don't remember saying that.
And he said, let's just stop talking about this for a while. I need to think.
He was yelling at me.
So he's yelling at you, but you weren't sitting there like you are now, were you? You weren't sitting there like this.
I guess I was buckled into the car, so I probably would have been sitting further back.
And you didn't stop. And then you get home, you're still arguing, correct?
He was still yelling at me, yes.
And you're not yelling at all. And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house, correct?
I'm not sure why he had it, I guess.
Okay. And it was in a holster.
I believe so.
And you both used to carry guns. You carried guns on a regular basis.
Yes,
You
ma'am.
have had at the time more than one gun.
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis.
I haven't been to the range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra.
Yes, that's where I concealed carried.
Okay. So having a firearm in a car or in the house is not that unusual to you.
No, ma'am.
All right. So after you decide, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva.
I don't recall that.
And you say he was waving a gun around and threw a gun at you.
Yes, ma'am.
So he has a gun in his hand, could point it at you,
He did point
but
it
he
at
throws
me.
a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall.
Yes, ma'am.
Okay. When was this? What was the date of this argument?
At the end of June.
2017.
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you'd been married before, you were now having a wedding reception.
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come,
I'd say maybe a dozen. Like my friends and family came.
and they're dressed up.
Yes.
You're in your wedding dress.
Yes.
Okay. And I'm going to show you State's Exhibit 10. I want you to tell me what this is. Or I'm sorry, it's 100. I want you to tell me what this is. It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is that at the same wedding reception?
Yes.
And State's Exhibit 102. What is that?
It's a picture of my friend Laura and me, and then my friend Christy.
And this is also at the same reception?
Yes, ma'am.
Okay. State, we move into evidence states 100 through 102.
Any objection?
I'm sorry, I missed it.
Any objection to states 100, 101, 102?
No, Your Honor.
Received.
Thank you. And in states 100, are you scared here of Doug?
No, I would not say.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh, no, not at that moment, no. That was a very nice day.
How about at this moment?
Oh, it was a good day.
And states 102 at this moment?
Same, it was a good day.
So you get pregnant and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay, but going to your mom's house was your choice, right?
We decided together, he said that he couldn't take care of me, he was too busy, and that my mom could take care of me better, so I was happy to go.
You needed someone to take care of you while you were pregnant.
I was really sick, yes.
Okay. So you moved down with your mother at maybe August of 2017, you said?
The end of August, I believe.
Okay. But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina-Florida thing, correct?
I'm not sure I understand the
Well,
question.
you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So she